So, good evening, everyone, and a warm welcome to all the distinguished guest speakers and participants joining us for this special IPNet webinar. Today's session is a unique confluence of innovation and insight, where we unveil a path-breaking legal technology platform and also engage in a rich conversation on using CaseEase effectively in insolvency practice. Before we begin, just a quick housekeeping reminder, please keep your mics muted, videos opened at all times, and use the Q&A box to post any questions for our experts. Now, let's dive in. To begin this event, I'm pleased to invite Ms. Tina Saraswat, who is the Regional Head, Central Zone of IPNet, to deliver the welcome address and to set the tone for this important evening.
Thank you, Namrata. Good evening, everyone. On behalf of IPNet, it's my absolute pleasure to welcome you all to today's webinar. We are truly honored to have your presence with us, and we thank you for taking the time to join this important session. At IPNet, am I audible? At IPNet, we are committed to fostering knowledge, innovation, and meaningful dialogue around various topics for the growth of profession and profession. Today's session is a continuation of that mission, bringing together experts, professionals, and enthusiasts from various diverse backgrounds to share insights, ask questions, and grow together. In the first session, we are privileged to host the Case Law Power Chat on the theme Use of Case Laws in IBC, Turning Precedents into Practice, featuring distinguished speakers, experts, Dr. Ashish Makhija and Mr. R. Hari Prasad. This session promises to equip all of us with practical insights into leveraging case law effectively in day-to-day practice. The second session is all the more special by the gracious presence of our esteemed chief guest, Honorable Justice S. Ravindra Bhatt, and also the launch of CaseEase in the second session. We hope this webinar not only informs you, but also inspires you, and that the ideas shared here through the Case Law Power Chat and the software launched CaseEase will spark new thinking and collaboration beyond this virtual space. A big thank you to our speakers and moderators for contributing their expertise, and to each of you for being part of this learning journey. Once again, welcome to the webinar. Let's make it an engaging and impactful session. Thank you.
Thank you so much, Ms. Tina. Now, let's move to the Case Law Power Chat, where we bring together two seasoned voices to discuss turning precedents into practice, none other than Dr. Ashish Makhija sir and Mr. Hari Prasad sir. It gives me immense pleasure to invite Ms. Veenu Dral, our moderator for the session, to take over and lead this exciting discussion.
Thank you, Namrata. Thank you, everyone, for staying with us. We now move to a truly exciting part of the evening, the Case Law Power Chat. Our theme, Turning Precedents into Practice, goes right to the heart of what insolvency professionals and legal practitioners grapple with every day. How to make judicial decisions work for us in real-world scenarios. I have two distinguished experts, Mr. Ashish Makhija, a leading legal authority and an academic voice on IBC, and Mr. R. Hari Prasad, a seasoned insolvency professional with extensive practical experience. Mr. Hari Prasad is a registered insolvency professional with a rich and diverse background spanning banking, law, and insolvency resolution. During his distinguished tenure at the State Bank of India, he managed high-value corporate accounts and gained extensive experience in credit processing, account maintenance, NPA management, and vigilance matters. Following his retirement, Mr. Prasad transitioned into legal practice and is an active advocate and a member of NCLT Hyderabad Bar Association, where he has represented various stakeholders in insolvency matter. As an IP, Mr. Prasad has played a pivotal role in CRP process, overseeing the management of corporate debtors and contributed to the successful resolution of his distressed assets. His combined expertise in banking operation, legal strategy, and insolvency proceedings makes him a resource in discussions around the practical challenges and opportunities under the IBC. Dr. Ashish Makhija is a distinguished legal practitioner and academician with expertise in insolvency law, corporate governance, forensic audit, and corporate litigation, with top academic and professional credentials, including a Doctor of Judicial Science from Emory Law School, USA. He brings unmatched depth to his practice. He is a chartered accountant, cost and management accountant, and holds a dual LLM degrees, one from India and another in international bankruptcy from the United States. As a registered insolvency professional, Dr. Ashish Makhija has played a pivotal role in advisory and resolution assignments under the Insolvency and Bankruptcy Court. Previously, he has served for 6 years as standing counsel to the official liquidator, Ministry of Corporate Affairs, attached to the High Court of Delhi. He has also served on corporate boards as an independent director and has been a member of various expert committees of national importance. A profile author with 14 books, including titles of insolvency and corporate directorship, he is also a World Bank trained corporate trainer and adjunct faculty at the Indian Institute of Corporate Affairs, Ministry of Affairs, Government of India. Dr. Makhija's multidisciplinary expertise and scholarly contribution make him one of the most respected voice in India's legal and corporate ecosystem.
Okay.
Let's dive in. I will be alternating my questions between both experts to give our audience a 360-degree view on law and practice. So we'll be taking questions from the audience side by side. So Makija sir, should we start from you?
Yeah. Okay. Thank you, Vinu. Friends, I think we are all waiting for a grand launch of CaseEase. The Honorable Justice Ravinder Bhattji, I think he is expected to join us any moment now. So the moment he joins us, I think we'll begin with that. But in the meantime, since we have some time, so therefore we'll start with the second session, which is case laws, the topic which is there. So we want to talk about the case laws, how to make use of those case laws. Now, that's an important thing. So from judgments to strategy, how to use case laws to really go about the IBC. Friends, it's my privilege to speak to you on the subject that lies at the very heart of every effective IP's practice. Now, interpreting and applying case laws under the IBC, it is not just as a legal precedent, but I would say as a strategic guidance. Now, let me begin with a very simple truth. IBC, we all know it is a code, but let me share with you something. IBC is not just a code. Let us call it as a core, C-O-R-E. In fact, I would also go to that extent. It is a battlefield of rights, duties, timelines, and consequences. And I think all you see IP friends will agree with me. So when I say core instead of code, now here C stands for consequences, O stands for obligations, R stands for rights, and E stands for enforcement of timelines. I think these are the four pillars of the IBC. So therefore, I always say that at the core of IBC lies a very delicate balance of rights, obligations, consequences, and a time-bound enforcement, isn't it? I think we have all seen in a lot of judgments about these things. And in this battlefield, case law is our compass. Typically, we think the case laws or the judgments as rear view mirrors, tools to kind of look back and see how the courts have interpreted various provisions. But I would like to suggest something more ambitious, I can say that. I want you to see the case laws from a strategic lens, a way to how to shape our decisions today and anticipate how these will be viewed tomorrow. So what the courts have decided in the past becomes a guidance for the future. So typically, friends, more than reading the ratio, that is my first tip out there. Reading a judgment is not about quoting the final paragraph. Well, that is where all of us or many of us stop. We say, oh, what the court has done. The real value, my dear friends, lies in understanding why the court ruled the way it did. So therefore, every Supreme Court judgment, if you look at it, every High Court judgment or even NCLAT judgment rulings, they will carry different layers. The first layer is the factual matrix. The second layer is the legal tension between the competing provisions. And the third will be the policy influencing the interpretation. Now, when we examine the SR Steel judgment, or when we examine the latest judgment of Bhushan Power and Steel, what do we see? Well, typically we look at in a different context altogether. But if you look at very closely, now you will typically find a very delicate balancing act, like in Bhushan Steel, public law versus IBC, isn't it? So therefore, these nuances are kind of will influence your resolution plan strategy also. So what I can tell you, my dear friends, is this: do not just memorize ratios, absorb the reasoning. Now, because reasoning it what will prepare you for new scenarios not yet decided. As I mentioned, factual matrix, reasoning, which typically in legal terms means as ratio. I think it is the most important aspect to find out a ratio. And it is the most toughest part also to find out the ratio. This is very, very important. Now, the only thing which I can mention you, and today I think we are going to get exposed to that, what AI powered platforms can do for us. Can they simplify the analysis? Can they simplify how we access and analyze the judgments? So if we have to, and it becomes typically with AI platforms, now it becomes easier than ever to focus on why behind the rulings, because I mentioned why is very important. Now this will enable the professionals, all IPs and all my advocate friends here, to move beyond the surface reading to the strategic understanding. Now this is very, very important. Now, what the judgments offer? The judgments typically offer clarity. And friends, according to me, clarity is power. Now, if you look at, recent judgments, they have changed the landscape, isn't it, of IBC at many, many platforms. We may criticize it, we may discuss it. That's another part of it. But sometimes it may add the uncertainty, but it may also open a window of opportunity. So for RPs and legal counsel, now the point, you see, that it raises every time a new judgment raises new questions. What should I do if this situation happens? This is where the strategy will matter. As practitioners, friends, now we have to really tailor our arguments. We have to tailor the drafts, legal drafts, not just around what the law says, but what the courts have understood it to mean and why. Now, these are very important, right? So not only what the law says, but how the court have understood and why. These are very important. So today, what is important is facts, issues, ratios. If they are given to us in seconds, reading a 100-page judgment, 125-page judgment, 300-page judgment, well, it is going to take time. But if we can get that in a very, very accurate manner, well, will this empower us or not? Now, this is where, because the timelines are very tight, we all know, and the strategy becomes very, very critical. So I think this is the one way which we have to look at it. Now, let me also be very blunt, my dear friends. Every major step you take as an IP, admission of claims, rejection of claims, constitution of COC, related party transactions, exclusions, avoidance transactions, is a potential litigation trigger. And we have seen that over a period of time. Now, what protects you? Not the legal counsel, the case law awareness. Now, that is very, very important. Now, if you have rejected a claim, have you followed Swiss ribbon guidelines? You appoint a valuer. Have you seen what Binani Industries talks about fair value versus liquidation value? You allow a plan later. Have you reviewed the ArcelorMittal decision? I think every action under IBC must be taken with a mental checklist of precedents. So friends, this is important. Not only the checklist under the IBC, but a checklist of precedents is also required to be prepared. Because one wrong step, it could lead to delays, it could lead to reversals and loss of confidence in the entire process. So friends, if we have an instant access to the right precedents, that is one very important. Not just a keyword search. I mean, if I search with, say, CIRP, insolvency, the I think Google will throw up, more than 100,000, search results. But if I get a contextualized summary, that can be a game changer in ensuring that I can defend those decisions. Now, case laws, when you look at a case law, not just as a precedent, but as a warning also. And if you look at that way, I think all IPs become better strategies, isn't it? I mean, we know that this is going to have, this has been held by one of the courts or the top court. Naturally, we will take care of this, isn't it? So Supreme Court, in a number of occasions, have emphasized timelines. Typically, in the last BSPL case, Bhushan Steel and Power, we have seen that the resolution plan, which was filed later than the timelines, I think that was also rejected. They said, how could the NCLT, in fact, the strictures were passed against NCLT, that how could NCLT, even consider such a plan? Of course, a review has been filed. This has been, a status quo has been ordered. We'll see what is going to happen at the end of the day. But today, there is a judgment about it. And of course, the judicial stance on delay intolerance. Now, if we know about that, we will typically build our timelines and we will ensure that there is a discipline. Now, that is a strategy, my dear friends. It is not merely a compliance. Compliance to timelines is perfectly fine. You are going to do that. But if you know that, okay, it is going to, there has to be there will be an intolerance about it, I think that, I call it as a strategy. So my submission is, my dear friends, case laws should not be reactive. They should be preventive. This is very important. And today, there are going to have, going to be a smarter tools which should be assisting us now, so that we can proactively scan for what are the red flags going to come. We can identify the cases and the relevant jurisprudence and the factor in those insights much earlier in the process. Isn't it? That is very important. Now, one more important, thing which I want to mention in strategy: learn the art of persuasion through judgments. Now, if you really want to convince a judge or you want to make a compelling submission, now you must study how the judges think. Look at how the Supreme Court judges write. They don't simply cite provisions or write provisions. They typically, if you look at any judgment, they tell you a story. They build logic. So if you are also drafting whether an application or a reply or even a resolution plan, I think we should follow the similar kind of a structure. What is going to be that? Start with the context and never leave that thread. Highlight the judicial support. You can anticipate the objections. What are going to be the objections in future? And then you must show proportionality and balance in your writing. So judgments are our training ground for this kind of an art. So, but if we get such kind of a platform which brings the judgments to the forefront, which are laying out the facts, issues, ratio, reasoning, then typically we can always sharpen our ability to frame the arguments in a persuasive manner. Now, I will end with this call, my dear friends. We must build a culture of case law discussion, and not only discussion, application in our community. So I think at IPNet, being the president of IPNet, I think now there is an onerous responsibility on us also to hold such kind of programs where we can discuss threadbare the case laws. I think we discussed Bhushan Power and Steel for almost 3 hours. So we are going to do that not as an academic exercise, but as a practical toolkit. So we have tried to create spaces where law is dissected, law is shared, law is also debated and also transformed into certain action points. So I call upon and urge each one of you, whether you are a IP, whether you are a lawyer, whether you are a stakeholder, to do just 3 things, my dear friends. Number 1, bookmark key judgments. Maintaining your own digital digest is extremely crucial. Number 2, we have to use those platforms which aid that structured understanding. Not to just read judgment. Reading judgment is fine, but learn from that law. That is more important. And thirdly, we need to discuss it openly, typically in webinars, maybe in other groups, and interpret the law together. Now, that is the key. That is what is important. Because according to me, my dear friends, an informed IP community is an empowered IP community. So now IBC is, as we all say, IBC is still young. Of course, it is almost 9 years old, but it is still young, right? It is not in double digits right now. So its jurisprudence is still evolving. We are not just followers, my dear friends. We are participants in shaping it. Let's not just cite judgments. Let's use them to build strategies. Let's interpret them as roadmaps. And let us also ensure that every step we take is backed by the two pillars. What are those two? Law and logic. Thank you so much, friends. I think we'll also field questions after we hear from our friend, Mr. Hari Prasad. Thank you. Over to you, Vinuji.
So should I start asking question or
No, I
should
think,
we take questions?
yeah.
Yeah. So if the audience will have any question, we will take you in meanwhile. So one by one, I'll be asking the questions. So Ashish, sir, there are instances where tribunals have deviated from earlier rulings. How should professional deal with conflicting precedents across forums?
You are asking this question to me? I'm sorry.
Yes, sir.
Ajay, can you repeat your question? I'm so
Sure, sir.
Yeah.
There are instances where tribunals have deviated from earlier rulings. How
Right.
should professionals deal with conflicting precedents across forums?
Okay. So dealing with conflicting provisions is very interesting question which you have asked. Number one, as we are aware, supposing there are two NCLT benches which are giving conflicting. First, the Supreme Court also says that they should not be conflicting. Rather, the one judgment of one NCLT bench is not binding on another. That is true. But Supreme Court still says that judicial sanctity must be maintained, judicial discipline must be maintained. So therefore, if you cite another bench's judgment, of course, they may not agree with that. That's a separate issue, but you can still quote it. It does not have a binding precedent. As far as NCLAT is concerned, definitely those judgments are binding on NCLT. But if there is a conflict within the same court, right? Let us take an example. Supposing the Honorable Supreme Court renders two judgments on different issues. So the fact of the matter is that those benches and the judges are typically very smart to notice that also, and then they refer the matter to the third bench, right? In Amit Gupta's judgment, you see there was a decision by the court saying that the secured creditors are entitled for on the they are entitled for on the basis of the security interest. Now, you see that also judgment came up, and this issue came up in another judgment before the another bench of the Supreme Court. Now, that particular bench noticed that judgment, but they say, sorry, we don't agree with that. So therefore, we are referring the matter to the Chief Justice of India to form a higher bench. So typically, the benches will take care of this. So there you will not find conflicting judgments. Of course, there were conflicting judgments insofar as Rainbow versus PVVNL judgment, right? Which was
Yes, sir.
which was typically given by our chief guest who is going to join us in a little while, Justice Ravinder Bhatt. So he gave a judgment in PVVNL. But if you look at very deeply, because we have to see, go in deep. If we go deeply, the judgment of PVNL is in liquidation, and the judgment of Rainbow is in CIRP. So where is the conflict? Of course, somebody may talk about the principle and other things, but the principles are typically different in CIRP and also in liquidation. So I think we have to always take it with a pinch of salt, understand what is the logic behind that judgment, and you will find a lot of differences. So we must have the ability to distinguish one judgment with another judgment. So I will say that if you go into those details, you will not find most of the conflicts will be able to resolve. Okay. Yes.
Thank you, sir. And now I would like to ask question for Mr. Hari Prasad. Sir, can you share a CRP or liquidation case where a precedent became the turning point in shaping your approach strategy?
Yeah. When it will become a turning point for any strategy or something. Okay, first of all, let me thank the IPNet team and our Ashish Makizaji, the president of IPNet, and all the participants who are attending the webinar. First of all, I feel that though they are called the insolvency professionals, in the eyes of the NCLT or NCLAT, they are all the semi-advocates. So it is a combination of advocacy as well as the insolvency resolution. So my dear friends, here what Sir was telling, the research is important. If you directly go away to the operational part of the judgment, you will know the result, that's all. But how it has been dealt, this is important to formulate a strategy for your future litigations, for future applications and everything. So first you narrow down the potential search terms and write down your own narrative. For the research, it is definitely one has to be familiar with the acts, regulations, rules, and everything. There are so many research sites like Manupatra, IBCLAS, SCC Online. But when Sir was referring to for the last 2-3 weeks, using the artificial intelligence to get the judicial pronouncement and to make them for our future use, to strategize our applications. It is really a new context. So I remember one thing, what Madam was asking now, let's come to the question directly. So any decision, if you follow it correctly, like when previously there was one bank guarantee case where the corporate debtor was having bank guarantee margin monies with the bank. After CIRP, the resolution professional asked for the return of the amounts, stating that they are the assets of the corporate debtor. But the bank refused to give, saying that, see, I have got some amounts to be claimed from the corporate debtor, as well as these are with my deposits. I got the lien marked on them, so I need not give it. It went to the NCLAT. This is the case of IOB versus Arvind Kumar, who was the RP for Richa Industries. There, NCLAT has clearly observed that only two situations will come. If the bank guarantee has been invoked, the margin money has to be paid along with the monies of the guarantee beneficiary to the beneficiary entire amount. If the bank guarantee has not been revoked and it has been expired, so there is no liability for the bank to pay to the beneficiary. So then automatically it will become the corporate debtor's asset. Using the same thing, I changed my strategy to educating my client so that after attaching these case law and asking the other bank, they simply have some approvals from their higher authorities, and without going into the litigation, they have refunded the money. This is how I used what I learned from the case study to my future litigation or the future success of the resolution. Thank you.
Sir, I would like to ask that have you came across any of the incident where you have looked for the judgments but you were not able to find any judgment? So how you have dealt with that situation?
Yeah, it is very relevant question. We use it to break our backs. It is very difficult. In spite of the so many research databases are there, so many sites, searching for the correct terms is very important. And above all, instead of getting the knowledge, what is the requirement of a client? What is the requirement for our case? And we should be able to predict the outcome also. And at the same time, it is very difficult. So we have to do proper prompt engineering, keeping the good prompts, then only we will get the good case studies. Otherwise, reading. As Sir was referring, it will not come overnight. There has to be everyday exercise. Like every day, you should go through some of the case laws, or at least nowadays, everybody is telling in the WhatsApp message and some messages. Just go through the outlines. If you feel that it is important and it is useful for your client, please make a note of it. You call it as a card making, signature, or whatever is directory, your own dictionary you should have. Then it will be easy for you whenever you need not remember anything. You just control F and search for your search term or the case against the PF department, something like that. you will get the case. Now, you can ask your counter neighbors, you can call our seniors like that. But now, in the form of some case studies, CaseEase, or by using the IA or artificial intelligence, it may be a good boost for us. It will become easy in future by making use of the full potential of the whatever product is being launched.
Sir, I have this question from Mr. Hari Prasad and Dr. Makija, sir. Sir, if we have to look for a judgment, so should we look for judgment on the basis of the section regulation or the facts of the case? Mostly people face issue while looking for a judgment. They are not able to find the relevant terms.
Okay, I think I will answer the previous question and also this question. See, at the end of the day, finding a relevant judgment is a huge task. And typically, out of 30,000 judgments, 21,000 of NCLT, NCLAT judgments, you add High Court and Supreme Court, there are almost around 30,000 cases now, more than 25,000. So to find out a proper judgment which suits your case, I think it is the huge task. Now, how to do that? One thing is that you need to know what is the proper keyword. Now, if you just search by CIRP, well, it will throw up, you see, a lot of cases. But then you have to be very, very specific what you are looking for. And going by section also, like simply you mentioned section 7. Now, section 7 would be mentioned in all section 7 application and judgments, isn't it? So therefore, it will again throw up the redundant results for you, which may not be very relevant. So this is an art over a period of time. You have to train your mind. So that is why that comes the artificial intelligence. Now, training a mind is typically very limited in the sense, of course, we have got a brain which can be trained to any extent, but at the end of the day, we have our own limitations. We have got hundreds of things on our mind. We have got hundreds of things to do, you see, in a particular day. So we need to really train you can say the artificial intelligence comes into this. And that is why you will see the benefit of that. But the only point is, and the word of caution is that it needs to be accurate and it needs to be contextual. Now, if it is not contextual, again, we are going to be a problem. You ask a question simple to Chat GPT, I think my friends will be aware, and I think most of them have also interacted with me, that sometimes it throws up with, you see, illogical cases and also wrong cases. So therefore, don't rely on Chat GPT alone, just on a plain basis. So therefore, if an artificial intelligence has been trained over a period of time to find out the proper judgments, I think that will be the best thing for us to do. So that is what you have to do. So searching with the proper keywords is the most important habit which we have to inculcate. That is very important. And that comes over a period of time. It's an art. Okay. Yes, Mr. Hari Prasad, you would like to add something on this?
Yes, sir, definitely, sir. I agree with you. Narrowing down and going for the proper search terms, this comes out of experience. But why an IP has to use this artificial intelligence or getting the case laws? So because the IP is expected to do a lot of things. For the duties he has to perform, he should have multiple heads and multiple hands. He has to manage the corporate data, or carry on the CARP process, liaise with all statutory authorities. It is not possible for the single person. So he needs time to spare with the other things also, so that the routine thing of the searching and getting the proper judicial pronouncement, if it is taken over by some other tool like artificial intelligence, it is very time. It will save a lot of time. But one should be careful of what Sir was telling, misinformation or something. If we put a wrong question, you will get a wrong answer. Like we used to think that GIGO principle, garbage in, garbage out. But if the database and the proper questions and the queries are prepared by a valuable or any organization which is backed with experience, then definitely you will get rather Kiko or Vivo, value in, value. Whatever you need, you should get exactly. So I think that we will test the artificial intelligence tool, the CaseEase, for our benefit. Thank you.
Okay, I think, Namrata, I think our chief guest has just joined. So friends, I think this is the moment which we were waiting for. Our chief guest, Honorable Justice S. Ravinder Bhattji, has joined us. Sir, if you can hear us, can we, with your permission, sir, can we start the proceedings further?
Yes, please.
Yes, sir. Thank you so much, sir. Thank you. Namrata, over to you.
Thank you, sir. Thank you so much. I would like to now ask Ms. Tina to give a warm welcome address to our chief guest.
Thank you, Namrata. Good evening, everyone. Respected Honorable Shri S. Ravindra Bhatt, Justice Supreme Court of India, esteemed speakers, distinguished guests, and my dear colleagues. It is immense pride and profound honor that I welcome you all on behalf of IPNet to the auspicious occasion. Today is a day of great significance, made all the more special by the gracious presence of our esteemed chief guest, Honorable Justice S. Ravindra Bhattji. Sir, your towering contribution to the Indian judiciary, marked by erudition, clarity of thought, and the deep concern for constitutional values, have been a guiding light for many in the legal community. Your judgments reflect a deep commitment to justice, equity, and rule of law. It is indeed a privilege for us to have you among us today. Your presence here not only graces this event, but also inspires each one of us, particularly the younger generation of legal professionals, to strive for excellence, integrity, and service to the cause of justice. We are truly grateful that amidst your demanding schedule, you have accepted our invitation to be the chief guest today. On behalf of IPNet and everyone gathered here, I extend a warm welcome and heartfelt welcome to you, sir. Dear all, today's webinar marks a significant milestone as we unveil CaseEase, Legal Intelligence Simplified, a pioneering platform by transition designed to empower insolvency professionals with structured AI-powered case law research and analysis. As we navigate the complexities of insolvency law, the need for reliable, accessible, and efficient tools have never been greater. And CaseEase is poised to meet that need. I am confident that today's program will not only showcase innovation, but also foster meaningful discussions that will enrich our professional journey. Once again, our heartfelt welcome to all and a heartfelt welcome to our chief guest. Welcome, sir. Thank you. Over to you, Namrata.
Thank you so much, Ms. Tina. Let's now take a short moment to understand the vision behind IPNet and how it's building a vibrant professional network across India. Please watch this quick video introducing IPNet.
In the fast-evolving world of insolvency and bankruptcy, professionals need more than just knowledge. They need a strong network, continuous support, and a unified voice. As the challenges of the insolvency profession grow, so does the need for a platform where professionals can come together, share their experiences, and find collective solutions. That's why IPNet was formed. Promoted by Transition, IPNet is more than just a network. It's a mission to unite insolvency professionals across India, empowering them with the tools, knowledge, strong leadership, and community support they need to excel. Our purpose is simple: to create a cohesive community of insolvency professionals that stands strong together, advocates for their interests, and drives excellence in every aspect of the profession. At IPNet, we believe in continuous learning and collaboration. Our activities are designed to ensure that every member stays ahead in their field, from specialized study groups that dive deep into critical topics like CIRP, compliances, and many more, to webinars and workshops that bring the latest insights right to your screen. IPNet is your gateway to professional growth. Backed by Transition, a leader in insolvency training and resources, IPNet is committed to promoting the interests of insolvency professionals. Our goal is to ensure that every IP, no matter where they are, has access to the best resources, strong leadership, and a network that truly understands their needs. Join us in this mission to build a stronger, smarter, and more connected community of insolvency professionals. Together, we can overcome challenges, shape the future of the profession, and make a lasting impact. IPNet, National Network for Insolvency Professionals in India.
Thank you so much. It is now my privilege to introduce our chief guest, Honorable Justice S. Ravindra Bhatt, former Judge, Supreme Court of India, a visionary jurist whose landmark decisions have enriched the constitutional and commercial law landscape in our country. Honorable Justice S. Ravindra Bhatt studied law and completed his LLB from the Campus Law Center, University of Delhi in 1982. He was enrolled as the advocate with the Delhi Bar Council in 1982 and practiced in the Supreme Court, where he was enrolled as the advocate on record of that court in 1989. As a counsel, he appeared and argued before the Supreme Court in several hundred cases and appeals, including cases and 80 judgments reported in the official law reports of the Supreme Court. These included appearances before panels of 5, 7, and 11 judges on important questions relating to the interpretation and validity of constitutional amendments, protection of minority rights, banking law, and corporate criminal liability. As a lawyer, Justice Bhatt practiced in public law, employment, education, and constitutional disputes. He was appointed as additional judge of Delhi High Court on 16th of July 2004 and as a permanent judge on 20th February 2006. During his tenure as Delhi High Court judge, he headed the Juvenile Justice Committee for 4 years and also presided over the first e-court in the country in 2009. He was appointed as the Chief Justice of the High Court of Rajasthan on 5th May 2019 and elevated as the Judge of the Supreme Court of India on 23rd September 2019. He retired on 20th October 2023. In his judicial career, Justice Bhatt has delivered many important judgments, the most notable one being about the obligation of Supreme Court and High Court judges to declare their personal assets to the Chief Justice and their coverage under the RTI Act, and in diverse branches of civil law, such as the right to let in DNA evidence in paternity suits, public interest in pharmaceutical patents, liability of internet intermediaries, trademark dilution, criminal law, capital sentencing, etc., and international taxation as well. He was appointed as the judge of the Supreme Court of India in September 19. In the Supreme Court, too, he delivered judgments in varied fields such as validity of constitutional amendments, intellectual property, arbitration, IBC, tax, and insurance. These include notable judgments and sentencing guidelines for death penalty matters, striking down of statutory gender gaps on women's participation in dance troupes as violative of the Constitution, disallowing tax exemption for supply of freebies by pharmaceutical companies, and ability of double insurance policies in India, interpretation of the term public policy, and scope for interference with foreign arbitration awards, insolvency law, etc. Justice Bhatt was the first High Court judge in the country to preside over a paperless and e-court. He was presented papers on intellectual property rights laws and addressed international conference, including at the World Trade Organization in June 2015, on intellectual property laws in Paris Conference in Melbourne in May 2017. He was also part of the Justice B.N. Sri Krishna Committee, which gave its report in 2017 on arbitration reforms in India by the Law Minister, Government of India in January 2017 in US, Tokyo, Japan. He was invited to address at Harvard University, which he did in 2023. We now request Honorable Justice Bhatt to do the honors and officially launch CaseEase, India's first AI-powered navigator for IBC case.
Can we have the presentation, please? Sir, we'll request you to please launch it, sir, so that we can officially show the video, sir.
I'll do that. I'm delighted to launch the CaseEase, the Legal Intelligence Simplified, a significant step forward in harnessing technology for legal research.
Can we have the video? The sound is not there. Can you? So just give us a moment. Some legal glitches are there. So, technical glitches are there. So.
Thank you, sir. To give a give you a quick snapshot of what makes CaseEase truly revolutionary, let's watch a brief introductory video showcasing its true core features and benefits.
I think, Namrata, we have already done that.
We've
So
done.
proceed with the
All
next.
right.
Thank
It
you.
was a beautiful video and a great launch, sir. Congratulations. And with this, I would now like to invite our Honorable Justice Butt to deliver the keynote address on evolving landscape of case law research, the role of legal technology. Sir.
Good evening to all of you. And once again, I thank you. First of all, foremost, Dr. Ashish Makhija, whom I have known for some time as a scholarly man and also very knowledgeable in corporate and insolvency laws, for this invitation. And I'm also delighted to be here amongst all of you and excited to launch this new platform, CaseEase. Having observed the attempts by, let's say, the early public sector creditors and rather unsuccessful attempts at recovering their advances. And I recollect having appeared and represented several banks as my clients in the different waves of different generations of laws which came in. First, we had the recovery of, the law of 1993, which set up DRTs. Then you had the securitization law. Then in between, in 1985, you had the SIC industrial SICA. So all this didn't really work. And for a long time, there were talks about overhauling the insolvency laws. And finally, that moment arrived. We had the 2016 Act, which was brought into force. And I think it's been a great journey. It's been almost a decade. But in this decade, we have seen an explosion of jurisprudence, not only by the Company Law Tribunal and the Company Law Appellate Tribunal, which have quickly gone about interpreting the nitty-gritties of laws. Invariably, when new laws are brought in, the transition is painful. But mercifully, in this case, I think the intervention of the Supreme Court, early intervention in at least a dozen cases in a span of about 3 to 4 years, has resulted in clarification of all the important gaps in the ironing out of the creases. So now we are here with the application stage where I think the role of professionals becomes very critical, because you have to make a deep dive into the case law and assist the tribunals in arriving at what is clearly a mandate of the statute, which is to quickly resolve disputes for the adjudicating authority, the NCLT, which finally would clear the applications or deal with liquidation proceedings, and thenceforward to the appellate tribunal. And normally it is expected that these matters end at that stage, unless there are important questions which will reach the Supreme Court. Having said that, I am aware that there's a lot of legal research going on in the field, and I think CaseEase has not arrived too soon. It's a very important and felt need for professionals. And having looked at the presentation also and read, as well as read about it, and having been one of the early pioneers as a lawyer of using case research through some of the earlier generation tools, I feel this is definitely a value addition, because you're using AI in the database itself, which means that you are asking questions and database answers you back with whatever AI tools are there. So unlike an uncontrolled search on Google, which often leads and throws up to hallucinations and false, answers, here we have a fixed database. The CaseEase is based on extensive data of insolvency laws and all connected legal issues and decisions based on those. So you have a very controlled database, extensive at the same time, and based on, and as well as statutes, as I understand, statutes, regulations. the entire universe of insolvency and whatever comes into it. So based on those decided cases, you have answers quickly coming up. And then it's for you to pick up those and actually fine tune your arguments. So I think it's a great beginning. And legal platforms, legal databases are very important in today's uh, in a professional's repository and repertoire. Without knowledge of these, without use of these, I think it's like a cricketer or a batsman entering the pitch without a bat. So today it's important that all students are very smart at this. But the next generation is when you have actually introduced AI, which comes out and not merely gives you a slew of cases, but also comes out with the answers, hopefully with cross references to the relevant case law and cases that have followed it. So I think it is going to be a very significant, revolutionary step if it promises to achieve even half what it is expected to. But at the same time, I would also sound a note of caution, which is that we should not entirely go by case law on legal databases. I think it's important to, if not have the textbooks and articles in the case law, in the legal platform and case in the database, it is important that these are also part of the curricula and professionals are at least aware of the basic principles, eternal basic principles, which are learned only by a critical analysis of the texts. Otherwise, we'll be just spewing out cases. So that's the one cautionary note I would like to give. And this is very important because you can think creatively out of the box. Basic principles like how to interpret a statute, how a scheme of the enactment is laid out. Now, all these are not these are not the outcomes of AI. This is the outcomes of centuries of refinement of legal reasoning and thinking. That should never be foregone. At the same time, you must embrace technology as you have, as your platform has, and present it to users, which I think your IP network will find tremendously useful. I think beyond this, I will not take any further time because the allocated time is also up. And again, I would thank the organizers and say that it's been a delight to be part of this event and launch this very revolutionary case database with AI as a driving force. Thank you.
Thank you so much, sir. We now express our gratitude to Honorable Justice Bhatt, sir. May I request Dr. Ashish Makhija, sir, eminent legal expert, to present a virtual memento to the chief guest and deliver a brief vote of thanks.
Yeah, it will be my honor, sir. We are presenting it on screen, on virtually. We request you to accept it. It will be delivered, sir, in a physical format to you, sir.
Thank you. Thank you.
Thank you. It is always a pleasure to hear from you and the words of wisdom. And I think, friends, as he also mentioned, that we need not to rely upon AI alone. I think textbooks are important, and not only textbooks, our own knowledge is also very crucial. Of course, AI can be helpful. So thank you so much, sir, for your presence today. Sir, would you like to take one or two questions from our participants, sir?
Sure, sure.
Sure. So friends, any question you would like to ask the Honorable Justice Mr. Ravinder Bhatt? Because I think, sir, a lot of questions have come up, like if there are contrary judgments by the Supreme Court on the same issue. So what should be the guiding precedent for all of us? And particularly, say, in insolvency law. As we saw, sir, the Rainbow judgment and your own judgments are in PVVNL. There was a slight, of course, it was in liquidation, one was in CIRP, so I may not see that conflict, but yes, the principle could be conflicting. So what should, as lawyers and IPs should do, and how to look at that, sir?
Now, as lawyers, you would all know that the general principle is that the larger bench binds the smaller bench. So if there is a clear-cut decision which is delivered by a larger bench, it may be 5 years before, 10 years before, or just 2 months before, that will bind. And the later judgment, even if it does take into account and tries to explain away the earlier judgment, the later judgment is not binding. The only caveat is that if the later judgment has carefully reasoned and given the reasoning why it is not following the larger bench because of certain facts, then the later judgment too could be, of great persuasive value. You will have to be very careful in distinguishing it or discarding it. You will have to analyze both the judgments and say which one is more apt to the fact circumstance. Now, as far as co-equal benches are concerned, which is what I think you alluded to when you referred to rainbow, I think the answer was in your question only. I thought that the previous judgment did not specifically refer to a legal provision. I think it was section 53.
Yes.
And also it dealt with a completely different circumstance, which is that was liquidation. And what is more, I think the whole history of section 53 and why that the order, the waterfall mechanism, and the order in which distribution had to take place was completely overlooked in the previous judgment. So these were the three factors, and I believe I think the review of my judgment has also been dismissed. So right now we have a dichotomy, as so to say, but the way I look at it is perhaps the way you, Dr. Mukhija, would also look at it. That if there is a liquidation scenario, then probably rainbow would be applicable, whereas in the normal insolvency scenario, when you are looking at settling claims as an IP professional, you would take into account related.
Yeah, absolutely right, sir. In fact, I was the standing counsel for official liquidator in Delhi High Court, and I'm really aware. And when I read your judgment talking about going into the details, history also of the waterfall mechanism, I found that it to be a very, very reasoned judgment, sir. Friends, any more question? I think this is a great opportunity. If anyone would like to unmute themselves and ask a question directly to our chief guest.
So I would like to ask, so what is your advice for the insolvency professional on using the judgments during the ongoing insolvency processes? So how could they improve the process?
How would they improve the process?
Yes, sir.
As insolvency professionals, you would be trained by the IBBI, and you would be given let's say, standard operating procedures. You would also have a toolbox about how to regulate your processes. But yet, at the same time, you would come across lots of claims. One thing you will have to be aware, which doubtless all of you are being experts, that the categorization, the statutory categorization of financial creditors, operational creditors, and the other class of creditors is to be respected. And there could be, while you categorize, that itself is a classification. Going further and making sub-classifications would perhaps incur the wrath of the courts, which means that, for instance, among financial creditors, if you say the recovery, you would be entitled to recover, say, 20%. You should not ordinarily be saying that somebody among the financial creditors should be entitled to 25%. So the point is, the principle of non-discrimination should be kept in mind. I don't know where it comes from, but it is there in the regulations, perhaps. Otherwise, you will always come under the Article 14 of the Constitution, will somehow get into your way. So to speed up processes, it is important to be fair, at least while recognizing the statutory classification or categorization of various classes of creditors.
Thank you, sir.
Okay, I think, sir, we'll take only one last question. Mr. Vikram Kumar has raised his hand. Mr. Vikram, I think you have to unmute yourself and please open your video because we may not permit you if your video is not on as a court process and the regulation. Mr. Vikram, can you hear me?
So, sir, good evening, sir, and it's a great honor to interact with you. So, my question is, with respect to payment to dissenting financial creditor, there are two judgments of Honorable Supreme Court which are contradicting to each other. One is the Amit Metallics case, and second is the matter of Ruchi Soya. Now, unfortunately, the matter of Ruchi Soya has been referred to a larger bench, but that order of larger bench is not still out. So, under these circumstances, where there are two orders of Honorable Supreme Court which are contradictory to each other, how can an insolvency professional deal? Because whichever case it follows, it actually, disobeys the other order.
See, this is a very peculiar problem which all of us, not only insolvency professionals, but also judges face, especially at the high court levels or judges even at the lower court level. Because when you have two contradictory judgments, normally you apply one which is most appropriate, as I explained earlier. But then if one of the later ones or one of them is referred to larger bench, then what's the point? The problem is, then which one do you follow? I would say that it would be appropriate that you take into account both the judgments and choose whichever one applies to you. And at the same time, if the one which applies to you is the one that has been referred to the larger bench, you may actually say that this is, of course, the view that we are taking for the sake of, to comply with the timelines, etc. But then if the law undergoes a change, then other consequences could follow, and that will be dealt with by the adjudicator. The final order, of course, will be by the adjudicating authority. Let them take that call, or the NCLAT, let them take that call, that in the case of a final decision to the contrary in the later judgment, that will be allowed, or some relief will be granted. Or from your side, you just close it. But be aware that these two judgments are there and one of them has been referred, and just mention it in the judgment, in your order.
Obliged, sir. Thank you very much, sir.
These kind of problems arise in a precedent-bound, hierarchy-bound, court system. So that doesn't mean that the work should stop. Work should never stall. Work should go ahead, and let the final call as to what is to be done in the cases which have come up in the meanwhile be taken by the higher courts.
Right.
Thank you very much, sir. Thank you, sir.
Okay, Namrata, I think we can proceed with the formal vote of thanks.
Vote of thanks for Justice Ravindra Bhatt.
Yeah, that's right. Yeah.
Yes, sir. I would request Dr. Ashish Makhija, our legal expert, to present the virtual memento we presented and to give the vote of thanks, sir.
Okay, I never thought it is my duty, but I think it's really a privilege, sir. So on behalf of, sir, the entire IPNet community, I would like to extend my heartfelt gratitude to you, sir, for gracing the launch of CaseEase as our chief guest, and also for delivering a very profoundly insightful keynote address on the role of legal technology. I think, sir, your words offered not only intellectual depth, but also a clear vision for how legal research must adapt in the age of digitization and artificial intelligence. Now, your reflections on the need for precision, contextual understanding in case law interpretation, I think that resonates deeply with all the participants out there. We are truly honored, sir, that you unveiled CaseEase, India's first AI-powered platform for navigating IBC case laws, and your presence has added great meaning and significance to this milestone. Thank you once again, sir, for your encouragement, wisdom, and also the continued support in our journey towards simplifying legal intelligence. Thank you so much, sir.
Thank you. You're welcome.
Thank you.
Thank you so much, sir. Thank you so much, Dr. Ashish Makhija, sir. Let us now witness CaseEase in action. Please join us for a 10-minute live demonstration of the platform and its key functionalities. Transition, please.
Yeah, okay. I think I will give a small live demonstration. So friends, when you log into your dashboard, and you will find this kind of, this is of course, you can see my name on the top of it. So therefore you need to register so that you can log into this dashboard. Once you come to this dashboard will give you a lot of facilities where you can really take advantage of all the facilities which are there and all the benefits which are there. Now, the first thing I would like to mention about the search bar. If you look at the search bar, it is on the top. Now, if you want to search on, say, like a Bhushan's case, so therefore, if we just, and this is a live demonstration, friends. So we are writing Bhushan here, and the moment we click the research, the search bar, the search button there, now all the judgments relating to Bhushan, Bhushan Power, whatever Bhushan name, wherever it appears, now you can see that they just got reflected in less than few seconds itself. And once you go to any kind of a judgment inside, of course, we will see in a little time, but you can also, supposing now this throws up a lot of judgments, but I want to see only say Supreme Court judgments are relating to Bhushan. So now I will filter it because there is a filtration is also there. Now I am only seeing the Supreme Court judgments on Bhushan Steel or Bhushan Power and Steel or whatever the name is there. So I think this is very easy. And in fact, it is in a very quick time, I think this has come up. Now, another facility is like you can clear the filters and then you can go on like a date. Like supposing we go on a select a date. So if I want to see the judge, supposing I remember a date, oh, on 9th June, that judgment came, 9 June 2025. Now I just click that particular date and now you can see that all the judgments which were delivered on 9th June 2025 are on your screen. And then you can scroll down in a little bit. Supposing there are a lot of judgments are there, then it will go page wise. So this is a complete clear facility for the search. You see, you can do it section wise, you can do it topic wise. So a lot of things are there. Now let us go and see the Justice Ravinder Bhatt's judgment only, which was Paschima Anchal Vidyut Vitran Nigam Limited. So I'm just giving with the code Vidyut. So I'm just searching by the word Vidyut only. So the moment I search with Vidyut, now it throws up again a lot of judgments. Now I can now filter it by Supreme Court. Look at this. PVNL versus HSA traders, PVNL. Now we don't know what the judgment of the Supreme Court was, which one was the Supreme Court judgment. Now, if I do that, now filtration by the Supreme Court, now I get to two judgments. And his judgment was typically this Paschimanchal Vidyut Vitram Nigam Limited versus Raman Ispat. So now if we go to Raman Ispat, my dear friends, when we click that button, now you come to a new screen. And on the right side, I would like to show you on the right side of the screen, if you look at the original source judgment is also appearing, which you can scroll down. 35 pages of that judgment is before you. You can zoom it, you can do anything about it. And if we come to the, you see left side, on the left side, friends, you can see the summary on the top. So if you just look at the summary, now we can scroll. What does it give us? It gives us the case background in just 5 sentences, 5 lines, analysis again in certain lines. So all these things, an action taken, what was the action which was taken by the court, what was the conclusion which was done by the court, every summary, every detail about that case is appearing. Now, if I specifically want the facts of the case, I will press facts of the case and the facts of the case will be presented to you in a very summary form. And then I want to see the issues and ratios. I will click on issues. Look at this. Now, issue was whether electricity dues owed to PVNL constitute a security interest under the IBC. Now, there is a ratio, there is a reasoning, and then there is an interpretation, and there is an how the court applied that particular thing. So what is the application of the law? And then there is a second issue which will come up, right? So second issue is this, whether it will fall under the government dues, whether they are affecting their priority under what we all know that this was one of the issues in that particular judgment. So this is the same way. If there are more than 2 issues, look at this. There is a third issue is also there. So that is also coming out here. So whether the judgment contains 1 issue or 10 issues, everything will come. Now I want to know who are the parties involved. I'll just click the tab of the parties. So typically I'll go to the parties. Here I know who was the appellant, who was the respondent, and who was the corporate debtor. So this has been done from the judgment by the, legal intelligence straight away. So you don't have to really look at this. And the timelines also. Look at the timeline. Now it is giving you in a chronological manner what happened in this case on this particular timeline. Now, friends, I must also draw your attention to the, last input bar, chat input bar is also there where you can click Ask Transition AI. Now, this is something which is absolutely unique and it will throw up such kind of answers and you will be surprised, my dear friends. Like supposing I need to, and there are sample prompts on the right side. You can just look at this. Yeah, here the cursor is there, sample prompt. So we have also helped you that what you want to ask. Like supposing you want to ask, say, what was the, create a timeline of significant events. So the moment you press that sample prompt and say, and press also Ask Transition AI, now it will work for few moments, and then it will throw up an answer very, very quickly, looking at the entire. This is what the judge was saying. The Honorable Chief Guest was saying, it is looking at, not at the Google with 100,000 pages or maybe 1 million pages. It is looking at that judgment only. Look at this. It threw up the, timelines in this particular manner. Now you want to say, copy it in a tabular format. So we can just simply say that give me the timelines in a tabular format. So just the moment I write that, give me the timeline in tabular of events in tabular format. Just writing down this in a simple English, press that Ask Transition AI and just wait for a few seconds, and then you will be surprised with the results. And you can look at this. Now the date and event has come automatically in just a matter of seconds. Now you can copy it, you can take it anywhere and you can use that thing. So you can typically copy and you can paste it anywhere you want. And similarly, there can be other prompts which can be there. Maybe we can use some other prompts here. Like supposing I ask the question, from which para, yeah, just write it down, from which para and from which page and para the findings in this case starts, because I don't want to go through 300 pages. I will ask that question. I want to just read findings and analysis, right? Findings or analysis, right? Rather than findings, we can talk about analysis also. So it will throw up, look at this. The analysis starts from page 8, para 10. Now, this is the kind of the help which we need. And look at this. We'll show you on page 8, para 19, whether this AI is correct or not. So on page 8, para 19, now you will find, look at this. This is the analysis which has started from page 8. This is so accurate. And similarly, we can ask other questions also, like we may ask another question. Yeah, can you type on another question? Any question which you like? Yeah. So what precedent? Yeah, supposing I want to really know what cases were relied upon. While the court wanted to decide this, what were the precedents which were relied upon in this particular case? So if we look at the precedents and if we ask that question, now you will find that it will throw up fantastic results. Look at this. These are the judgments which were relied upon in this judgment, just in a matter of seconds. You don't have to read the judgment. The this tool is telling you. Now, I want to know what are the citations of this case, because it has not given the citations. So I can ask, what are the precedents relied upon with citations, right? So what are the precedents which were relied upon with citations? So now if I just ask in a simple English language, you don't have to be perfect. You can write down anything relied upon with citations. So the moment I write down that with citation and I just say press Ask Transition AI, now you will find that it is now going to give you the citations of those cases which were also relied upon. So this typically, look at this now. Sales tax officer versus Rainbow Papers 2022 13 SCR 808. So it gives you a citation also along with that. Now you want to know which one are the Supreme Court judgments relied upon. I mean, within this precedents also. Now which ones are the Supreme Court which one of these are the Supreme Court judgments, right? Supreme Court judgments relied upon. So now if I type it simply here, now it will throw up and give you a list of not NCLAT or NCLT judgments. It will just simply give you, these were the Supreme Court judgments which were relied upon. Because at many times I would like to read only Supreme Court judgment, isn't it? Because they are the binding precedents. So I think this is something which is exceptionally doing it well. I think friends, use it like anything. Now, if you ask a question outside the legal platform, right? So it is not going to answer. So let me show you that also. Supposing here, okay, can we remain here? Yeah. Supposing we ask a question, who is Shah Rukh Khan? So if we ask this kind of a question, right, which is not relevant to, who is Shah Rukh Khan in this case? So let us see what the AI answers. So I mean, I'm trying to tell you that, look, this has been trained in such a manner that, look at this. This document does not contain any information about Shah Rukh Khan. So therefore, friends, this is so accurate that it is not searching Google. It is not searching anywhere. It is searching that database which is already there. And this has been trained over a period of time, my dear friends. So this is very exciting. And I think this is extremely crucial that we have to really deal with these aspects. Okay, I think now we can go to the other part of it. Mr. Vikram, just give me a moment. We'll just field the questions. Let us go to on the top. If you just look at it, there are things which you want to like make your notes on this case, right? Because so that you should not forget. So just add new note, and you can write down anything. Like you can write down, say, PVVNL. So supposing the case name, you just write down PVVNL2. You can write down 2 because 1 is already created. So PVVNL2, and you can write down the ratio is important in this case. Supposing you just want to make a note of it, right? Because you know that ratio of this case is related to this and it is very important. Just save your note and it will remain forever in your dashboard. And you can come back and see, because you don't have to search the document again. You can just open your notes anytime and it will give you the what you noted down. So you don't have to search everything again. This is fantastic, friends. Now, if we go back now, I think we are all done with, yeah, we can also do bookmarking. So I'll just show you bookmarking. So just press the dashboard. Just go back to the dashboard first. Yeah, let's go back to the dashboard. So if we go back to the dashboard, friends, now you will find, again, we are coming back to the main page. And here, supposing I want to bookmark, like first two cases have already been bookmarked. Can you unbookmark those first? Yeah, just untick them. Okay, yeah, supposing it's, yeah, okay. Like this, the first case, Elegance Malls Limited. So there is a bookmark sign. So I'll just bookmark it. Just do the bookmarking here. So it has now been bookmarked. And on the right side, on the top, you can see that bookmark cases are already appearing there. So those cases are appearing, all bookmark cases will appear. So whatever you have bookmarked, because you find that these are relevant for your search inquiry. And then you can enter into that case, look at the summary, facts, issues, ratios, parties, date, every damn thing you want to know about it. And supposing you have bookmarked 100 cases, there is a search facility within the bookmark cases also. So that is also possible. And now if we go back to the dashboard, there is a beautiful facility now, my dear friends, that this, you see, application or software contains a lot of databases there, right? I mean, I mentioned to you that for IBC matters, there are more than 25 to 30,000 cases are here. Now, for 30,000 cases, now it becomes really very difficult. And sometimes there may be a certain case or certain NCLT judgment which is not there, but you have a control of it. Or assuming, let me also give you an example, like Mr. Hari Prasad is arguing a case in the court and he quotes a particular case. You are also sitting on the opposite side. You have not read that case. You have the, this application before you. You find out that judgment, and then you can upload that judgment here. Here you can find out on the bottom, you say upload your cases. Now here there is upload your legal document. You can upload your case there And the moment like it is being uploaded, so it will take you to your own, see when you try to put that, so you can drop a PDF and then it will take little time for uploading, and then it will also analyze that document instantly for you. So this becomes very important. Like while I'm sitting in the court, somebody is arguing the case, and I want to know what are my distinguishing features on that. I think I can really use this facility. The moment it is uploaded, of course, uploading depends upon the speed of the internet also. And once it is done, you will find amazing results. And again, you can ask questions. And you can say that I want to make this case as distinguish this case, and then immediately you will be able to find out this. So look at this. Now this judgment has been uploaded now. Once this judgment is uploaded, you can find your summary, you can find facts, issues, ratios, everything which is available. And on the right side, the document is also appearing. This is the latest judgment of the Supreme Court, Bhushan Power and Steel. And now you can ask any question to the, you see, Ask Transition AI. So what are the distinguishing features or whatever question you want to ask? I think we have already, who are the judges in this particular case, right? So that is an answer. Who are the advocates in the present case? Where the facts, from which para the facts start? I think you can ask any question, my dear friends, relating to that particular case, and the answers will come up in very quick moment. So you don't have to rely upon, look at this. The judgment was delivered by Justice Bela Trivedi and Satish Chandra Sharma. This is what the AI is doing, CaseEase is doing. So as the name suggests, it makes your research very easy. That is what the name is, CaseEase. So I think it's a beautiful application. I think we have covered all the features. Maybe on the left side, can you show certain tabs which are there? The first tab is of AI, Transition AI. The second tab takes you to the dashboard. The third tab, you can see bookmark. So whatever cases you have bookmarked, you can find out here. Then the next one is, we'll talk about the browse cases by topic. So already a lot of topics have been identified. Maybe you can search with the other keywords also. And then of course, browse cases by sections. I think somebody asked a question, if I want to know what are the section 7 cases. So you can browse cases by sections, browse cases by time. And then of course, the last one is the uploaded cases. So whatever cases you have uploaded, now the repository will always remain there. This is what is very crucial, my dear friends. So I think this is something which is very intelligent and very accurate. So mark my words, I think I have also used it for some time as a user, but I think many other people have also used it. So I'll just end up my presentation here and hand over it to Namrata for further proceedings.
So we take the questions now, we take it later, sir?
We'll take it little later. I think there are some announcements to be made here.
Yes, one special announcement by Transition founder and CEO. Before we do that, I would like to introduce the Transition founder and CEO, Ms. Rashmi Makhija, ma'am. Ms. Rashmi is a seasoned professional with over 35 years of experience as a chartered accountant and company secretary, known for her sharp business acumen and visionary leadership. As the founder and CEO of Transition, she is at the forefront of transforming the insolvency ecosystem in India. Under her guidance, Transition has launched innovative tech-powered solutions that are redefining the way insolvency professionals work, streamlining processes, enhancing legal search, and setting new standards for efficiency and excellence. To share a special note on how CaseEase came into being, I now invite Ms. Rashmi Makhija, ma'am, who's the founder and CEO of Transition.
Thank you, Namrata. Good evening, everyone. Today is truly a special day for all of us at Transition. I'm absolutely delighted to share that the hard work and relentless effort of our team over the last 1 year has finally seen the light of day. The result is here. CaseEase, a platform that signifies legal intelligence like never before. This journey began with a simple question posted by our experts. With the increasing number of IBC cases, some running into hundreds of pages, how can we make the process of understanding and analyzing judgments quicker, more accurate, and more reliable? That question sparked an idea. an idea to responsibly harness the power of artificial intelligence, and thus Transition AI was born, carefully trained within the IBC ecosystem over the past year to provide contextual, dependable, and user-specific insights. Many of you may recall that Transition recently launched the most user-friendly software for managing personal insolvency cases, from initiation to closure. It helps you manage the entire process efficiently. I strongly encourage you to explore it if you have not done it already. You just saw a live walkthrough by Dr. Makhija of CaseEase. Now let me elaborate on why it makes it truly special. Every case under IBC available on CaseEase comes with a smartly structured summary highlighting facts, issues, ratio, timelines, and parties involved. It's research made easy. You can interact with any case in the database through Transition AI, whether it's simple query like, give me the timeline in a tabular format, or a complex one like, what is the most important legal point in this judgment? You will get instant, accurate, and contextual answers. If a case isn't already in our database, upload your own judgment and get an instant analysis. No more waiting, no more guesswork. Every judgment source document is just one click away, always available for reference and download. You can bookmark cases, create my notes, and organize your research with complete ease. And the more you use it, the more intuitive and indispensable you will find it. We are focused on delivering a clean interface, pleasing design, and a workflow that matches how legal minds work. And here comes the big announcement. We are opening pre-booking right now. The link is already shared in the chat box. And if you pre-book within the next 48 hours, you will get 15 months of access instead of the regular 12 months. You'll also get rupees 5,000 off the subscription price. Yes, you heard that right. 3 months extra and rupees 5,000 saved, but only for those who pre-book before the deadline. Before I conclude, I must extend my heartfelt thanks to our technical team, our backend warriors, and our beta users, whose feedback played a very critical role in shaping CaseEase. I would now like to invite few of our CaseEase testers to share their experience with us. May I first invite Ms. Manoranjani to share her thoughts? Ms. Manoranjani?
Hi, Lakshmi and everyone. Good evening, Dr. Atish Makhija, and good evening to everyone here. I had an experience of having a trial run on this, and I was really surprised by the opportunity, the facilities that this entire AI-driven database of case laws offers. We can just upload the judgment, and it gives me an opportunity to understand the case, the ratio differently, the legal principles behind it. And it's so very easy that I can do like earlier, if I had to read a case, it would take at least 1 hour for me. Now this whole thing gets me an idea within 5-10 minutes whether this case works for me, and I can do a large number of cases, and I can go for the appropriate case, what is apt for mine. And it has come at a time where I was genuinely looking for this kind of a software, and I'm going to book for this one immediately in your offer, Rashmiji. It's really amazing.
Thank you so much. Namrata, may I invite you to share your experience, please?
Thank you, ma'am. Well, I got to say that CaseEase is simply revolutionary. The platform instantly generates a structured case summary, that is facts, issues, ratio, and reasoning, which all are neatly laid out. And the best part, it is accurate, it's fast, it's wonderfully formatted. As an IP, this saves us a lot of time reading long judgments, which most of us, not being lawyers, are not very used to it. But this CaseEase is not just a research tool, it is an intelligent legal assistant, which I'm going to use daily. Kudos to Transition for creating this wonderful platform, and eagerly looking forward to booking and getting my hands on it.
Thank you, Namrata. Thank you so much. And now I invite Tina to share her thoughts.
Thank you, ma'am. CaseEase is one of the most thoughtful features of CaseEase is how easy it is to bookmark important cases, navigate across topics and keywords. It is clean, intuitive, and made with the practitioner's mind. No clutter, no confusion, just a well-organized, smooth experience. I can already see this becoming my go-tool for every IBC assignment. So, as the word says, case ease, it has eased the life of IP. I'm very much thankful to Rashmi ma'am, Ashish sir for making all the efforts to ease the life of IP. Thank you, ma'am. Thank you, sir.
Thank you, Tina. Transition has over the years built trust through its products, publications, training programs, and legal applications. CaseEase is another meaningful step forward, a powerful blend of legal expertise and technology. And yes, a gentle reminder. As our chief guest also said, while AI is a powerful tool, it's not infallible. Always review outputs critically and responsibly. We look forward to your feedback, your suggestions, and your partnership in making cases even better. Enjoy the rest of the session and don't forget to pre-book now. Thank you. Over to you, Namrata.
Thank you so much, Rashmi ma'am. And with this special announcement, we come back to where we left off with Case Law Power Chat by two seasoned voices. And I invite Ms. Vinud Diral, our moderator, to continue our session from there.
Thank you, Namrata. So I would like to ask a question from all the participants if they have come across any of the incident where they have used the AI and faced some issues, or they have really used the AI while getting any judgment in the court. So Vikram has raised his hand.
Yeah, okay. I think Mr. Vikram Kumar has raised his hand. Yes, Vikramji, can you just unmute yourself? Yeah.
Yes, sir. I'm audible, sir.
Yeah, absolutely. We can hear you. Yeah, go ahead.
So my question is, I have, sir, 2-3 questions, if you permit me.
Sure.
Like first question, suppose I'm handling a case wherein I want to be sure whether the assessment process by EPFO is allowed or not during CIRP.
Right.
So I want to see whether EPFO can carry out an assessment during CIRP or not.
Right.
So how do I use this process of case law?
Okay.
CaseEase, sorry.
Okay, so in CaseEase, now it becomes very easy. Number one, you see, if you go to the topic list, browse by topics, you will find list of topics. And there is a search facility. So simply you want to type EPFO. So you will find out it will, you see, come down to a few topics. So it will filter those topics. And then you can also mention in a keyword assessment. So assessment, EPFO, CIRP, if you write down these three words, you'll be able to narrow down to your typical cases. So you may find 1, 2, or 5 cases or 6 cases on that. Then you can go on to those. You can read case summaries. You can see whatever is relevant for you, issues and this, and then you can read the full judgment, which is also available for download. I mean, it is not that you are just getting the source document. You can just simply click the download button. You'll get the source document also there and then. I think this makes the life of all IPs much easier.
Like what I'm trying to ask, sir, is it possible that if I put the question on the search box, is
Right.
assessment allowed by EPFO during CIRP? Suppose I put this question.
Right.
Will it throw right answers?
No, see, I'll tell you. If you put this question to any AI or in Google, it will throw up, you see, absurd kind of things, because you see assessment word, which is appearing in all 30,000 cases, it will show up.
Right.
Now, that is not what you want. What you want is the proper keywords, go one by one, start filtering in the topic box. I think you'll narrow down and you will come in just by 3 clicks, you'll be able to narrow down your search.
That is the first question, sir. Second question is, sir, have you also covered the disciplinary orders of IBBI in this?
Well, probably that is in the next phase.
Okay. Because why I was saying this so?
Yeah.
So this is a small suggestion to you.
Yeah.
Because I tell you, a lot of times we are actually, bothered by the COC to do something which is not allowed. So if we are able to quickly find out a DC order, give it to the COC that please note this is not permissible. It makes our life easy.
Well, I never wanted to let the cat out of the bag, but since you have asked, you can expect it very soon.
Okay, sir. And the third is, sir,
Already
exactly how much do we
We are
pay?
already on the job.
Already the
Sir,
team.
how much do we pay? How much do we exactly pay to get access to this resource?
Yeah, I think the link has already been posted. So,
Yeah, it's been posted.
so it has been posted. Just click that link. You'll go to that link. You'll find out. And as
Achha.
I think the it has been mentioned that you are getting a inaugural or a pre-booking discount of 5,000 rupees right now.
Right. Right,
Therefore,
sir.
and it is very, very compatible.
Correct.
And because we are, see, at the end of the day, you are getting AI facility. No one gives you that AI facility. So you can understand what, yeah.
Sir, last and not the least is my personal congratulations and best wishes, sir, for this great, exercise.
Right. Thank you so much. Thank you so much. Yes, Mr.
Thank
Haresh.
you.
So there he has raised his hand. Yes, Mr. Haresh.
Sir, good evening, sir, and congratulations. My question is, what is the time gap before courts giving judgment and getting updated here?
Okay. And that's a very important question which you have asked. Sir, I will tell you the moment the judgment comes, within 24 hours, it will be on the website. Supposing today the judgments are being uploaded, right? The system will take into account at 12 a.m. in the night. It will catch all the judgments and it will be in your database immediately, instantly. Even if 100 judgments come on a particular date, our system will catch those judgments within 15 minutes. And within 15 minutes, all those judgments will be updated. So you will find today's judgment tomorrow morning, 8 o'clock. You want to find it, you will find it.
Okay, thank you, sir.
Yeah. Okay, great question. I think that was.
Sir, can I ask one question, sir?
Yes, Mr. Sain. Yes. Go ahead, sir.
Sir, my question is that.
Mr. Sheikh, sorry. Yes, sir. Go ahead, sir.
Yes, sir. If there are some contradictory judgments between two judgments, the contradictory view by Supreme Court as earlier has been discussed.
Right, sir.
So suppose if I ask questions, what are the differentiation between the facts and contradictory view taken by the courts between the two judgments? Can it be compared and provided to me?
Okay. See, the point is, right now, the facility of comparing two judgments is not there. Today, in a particular judgment, if you want to ask a question, what are the facts of the case? You can copy it down. You can, paste it anywhere. Similarly, you can take the facts of the other case of facts you can compare, because those facts are not going to come in, say, 10 pages. They are going to come in only 7, 8 lines. So you can read easily and see, oh, okay, this is in CIRP, this is in liquidation. So I think you will be able to make a distinction very quickly. But you are right. I think we are noting down for the future further improvement, comparison of two judgments or more than two judgments. I think that's a valid point. I think transition probably is listening now.
Yes, we are noting down all the suggestions.
Okay.
Mr. Partha has a question. Can the search be made with two parameters simultaneously?
Yes, Mr. Sain.
Sir, I have a couple of questions. First
I just want to say one thing, sir.
Yes,
I think I'll be the first person to purchase after your.
Okay. Chalo, great.
Sir,
Yeah.
can the search be made by considering two parameters simultaneously? I mean, suppose I want to search Section 7 for in Supreme Court cases on Section 7.
Right. That is what I mentioned. See, one is that if you go to the browse by topic box, you will find a lot of topics, right? So supposing 500 items are there. Now there is a search bar. So you start writing Section 7 there. So Section 7 cases will come. Now that filter is already there. Now you want to add another filter. You can add another filter and both the filters will work simultaneously.
Okay, sir. Thank you.
That's
sir, my second, just I want to know, was the personal guarantor case also incorporated?
Sir, it covers the entire IBC ecosystem. Part 1, Part 2, Part 3, Part 4, Part 5. Except disciplinary matters, except disciplinary orders which are in the office.
How would be the support taken care, sir?
Yeah.
The problem issues that we want to discuss.
So on the website, we will be creating a kind of a WhatsApp group for the subscribers. So if you have any questions, so probably you will be able to get quick answers, right? Otherwise, that email ID and other things will also be there. I think Rashmi would be able to tell us in more detail.
Yeah, regular emails will be sent to all the subscribers regarding all the updates. Plus, of course, it will be added to the database as we just explained.
Can we have regular training programs? Because new people will keep coming adding.
I think
We
there
have,
yeah, sorry, go ahead. Sorry.
no, it's okay. See, we have already made some introductory videos and instructive videos, which are already there on the page. Still, if you have any issues, we are always there to help you. And if need be, we'll definitely conduct the programs.
Like you will
Your
find,
suggestion is, it's a very good suggestion.
like you will find take a tour button will be there. So you can
It's
take a
called
tour
Take a Tour.
and a new person who is coming out here, he or she can actually look at those and how to access and how to use this. So I think that's a
It's a
good.
kind of a
Like as you said, having multiple filters, comparing two case laws, these are like little complex things.
True.
Which for a period of time, we will, as we keep using, we'll get a lot more ideas to how to use this.
We are always open for these suggestions and we'll keep incorporating all these suggestions. We'll keep updating. It's not that it's just the end of it. It's just the beginning. So we'll keep updating the software and adding new features. In fact, it has taken us almost a year because we had to train AI and the number of times that we scraped it. I mean, we were almost there. We thought we are there. And then we said, no, this is not what we want. We want it even better. We want even better than this. So we scraped it, went to the table again, started from ground zero. So we'll keep adding the features. The suggestions are always welcome.
Good evening, madam. If I subscribe today in your pre-booking this thing, when the product will be delivered?
Sir, it will be available from 23rd.
Okay, thank you.
Yeah. You can get access from 23rd. Might be earlier also, but that's the deadline that we have.
Thank you.
Yeah.
Sir, I would like to ask a question. Can AI tools compromise client confidentiality or data privacy?
Okay, that's a good question. But insofar as the client confidentiality is concerned, we're not asking you to put the petition of or application IA on the AI facility. We are simply saying there is a public domain, there is a case law, right? There is no confidentiality in that. So if the case law is on a public domain, and if that case law is already not in the database, right? That is important. So you don't have to upload every time. But you have a case which is not in the database, you can upload that and you can find instant results. Otherwise, as far as the database is concerned, it is almost around 25 to 30,000 cases are already there, and they will be kept on adding on a daily basis, right? But so therefore, there is no question of any confidentiality here. But we are not asking.
So what are the biggest risks?
This gives us another idea. Your tool can even make applications now because it is AI.
I think in personal management, you see tool, which you will find there are already templates are there, isn't it? So
Yeah.
tools are already there. We don't want to go into those kind of things because that is prohibited by Bar Council. So please understand, legal drafting and legal consultancy is not possible online. This is prohibited. So therefore, transition cannot do that. Okay.
What are the biggest risk of using AI in legal practice and during the CRP process and other insolvency processes?
Okay.
Because IPs use these tools on daily basis. So what are the risks?
See, the point is, number one, if you are using Chat GPT or kind of uncontrolled, you can say AI or Gemini or whatever it is, now you are running the risk. As Manoranjani ma'am, she also mentioned to me and we spoke with each other, the AI gives you wrong conclusions, it gives you wrong case laws, it gives you wrong citations also. So don't blindly believe any.
Totally wrong case.
Totally.
Then when I say, why are you giving me this? It'll say, I'm sorry, I didn't understand. And it'll like talk like as though we are talking to friends.
Right.
And it'll accept. It'll say sorry.
Correct. So the point is, as far as this case is concerned, you can 100% rely upon, because as the Honorable Chief Guest also mentioned, it is actually answering from the database already with it. It is not answering out of the database. So therefore, you are not sure, you are sure that you're not going to get wrong answers. So your answers will be totally accurate. As I just showed you, like if I ask a question, from which page the facts of the case begin, right? You just want to straight away go. It will tell you para 8. Go there and see whether para 8 is correct or not. So I think this is something which is very crucial. So don't use generic AI, use trained AI like CaseEase. That will give you better results. Okay. So
So how can professional verify the accuracy of the AI generated content?
okay, I think Mr. Hari Prasad should take that question now.
Ultimately, it is the human intelligence that overrules the artificial intelligence. So whatever the validity, whatever it has given, we should have the managerial look over there, at least the legal company, legal these things. Otherwise, it will create a havoc. We
Right,
should use the human intelligence for supervision.
right. I think yeah, I think that's a great answer. You cannot undermine human intelligence. You cannot undermine the textbooks. I think this is what the Honorable Chief Guest also mentioned, that books are also your friends, right? But at the end of the day, for the research part, AI tool can be used in a very limited manner. But as Mr. Hari Prasad also mentioned, and there is a disclaimer on cases also, that you have to check the accuracy. I mean, analyze it and think, you see, with your mind, whether it is applicable to my case or not. So I think that's very, very important. Okay, I think there are a few questions, Vinu, on the chat box also. Dr. Abhiman Singh says enormous case laws are one of the main reasons of huge pendency and delay in fast disposal. We agree, sir. In my opinion, only those case laws which have been delivered by full benches with 75% assent should be considered for reference in future cases. This may be a tedious task, but it'll ease the system. Okay, Dr. Abhiman Singh, the answer is like this. As far as NCLT judgments are concerned, two benches, two members are there, and both of them are agreeing. So it is 100% consent, right? Isn't it? In 99% cases, you will find 100% consent. So therefore, all judgments have to be read then. Similar is the case with NCLAT, and similar is the case with the Supreme Court. But in law, in our Indian law, it is the majority which typically rules. Like supposing it's the Supreme Court creates a higher bench of 11, and 6 are on one side and 5 are on the other. So the judgment gets it's delivered the way the 6 judges have decided. So that is the law which we have to follow also. Okay. Yes, Mr. Hari Prasad, any comments from you on this?
What I would like to add is, it is the best to take away the labor from us, unnecessary time
Right.
for the basic purposes.
Right.
Whatever the lawyer or the IP has to do, that we have to do, but it will reduce the time.
Absolutely.
Efficiency will increase.
Efficiency will improve, and because at the end of the day, time is limited with us, isn't it? So with the help of AI, we will be able to analyze it better. We will be able to find out the ratios in a much quicker manner. Okay, Parag Singhal ji says how to deal with artificial intelligence in court. I mean, are you talking about the artificial intelligence to be used by judges, or I mean, what exactly is your
Artificial intelligence by benches.
by benches? I think they should start using cases now. Then they will be able to find out the judgments quickly on their own with rather than relying upon the legal researchers there. So therefore, I think it will make their task much easier. Okay, I think
Sir, basic problem. Sorry, sir. The
yeah.
basic problem that I think is benches, honorable benches are more concerned about having precedents rather creating precedents.
You are right. Actually, that has become the system. In fact, I've always quoted this when I was appearing in 2017 when the IBC law was new. One of the benches, the judge asked me, he said, Mr. Makija, do you have any precedents in this matter? Now, in 2017, how can there be precedents? And I simply mentioned to the judge, I said, my lords will set the precedents. So
Yes.
then the judge was very happy. He said, yeah, I'll set the precedent now. That should be the attitude. I agree with you. That should be the attitude. Right. I think Mr. Avinash Tripathi is there. Yes, sir.
Sir, am I audible?
Yes, sir. Go ahead.
Sir, just now you had mentioned that in NCLT normally we have two member benches, and there are hardly any judgments where we will have a differing opinion.
Correct.
Very recently, I had come across one decision of bench 3, probably NCLT Mumbai.
Right.
It was a bench of, I think, just Rita and Madhu Sinha,
Right.
where there was a dissenting opinion of one of the members within that. And then that was resolved, I think, by using the third member or maybe the president of the bench. But
Correct.
there was a judgment in which there was a differing opinion.
No, I mean, I'm not saying, I mentioned, if you recall, I said 99% of the 1%, there was one Calcutta bench also, which differed. So two members
Hyderabad also, sir.
Yeah.
So
Hyderabad also it happened.
Yeah, Ahmedabad.
so I just wanted to add to that, sir. It was not to say that it hasn't ever happened. It does happen. And anyway, sir, thank you very much for coming up with this new platform. I have already pre-booked.
Chalo, thank you so much. I think you'll find it useful. Once you use it, if there are any suggestions, any feedback, please send it to us so that at least they can be improved upon. Right. So we'll also eat up your brain on this particularly, that yes, this is the improvement which is required.
Sir, I should say something, sir. May I allow, sir?
Yeah, go ahead, sir.
Sir, I have an experience of using the ChatGPT, sir, and whenever I ask the ChatGPT to get the case laws, the ChatGPT doesn't have access to the database of the any database of these case laws. It always search on the web.
Right.
It is not searching the database of the case laws. That's why they used to give the wrong case numbers or whatever available in the web. They have to put it on to me and saying that this is the case. When you verify that case law, then it is different from the facts of the matter.
Right.
So now CaseEase is very good. I saw that this is an excellent tool so that RPs or even advocates or anybody can access the precedents with ease immediately, because it is accessible to the database, official database of NCLT, NCLAT, and Supreme Court. So exact case laws come out. I had already subscribed the
Great, sir. Thank you so much. I think once you use
it is an excellent product.
I have a question.
Yeah.
So, is this subscription for single user or multi-user? How it will
go? See, it is for a single user because at the end of the day, the products cannot be made, available to a large number of users, right? But at the end of the day, supposing in your office you want to use it for, say, 3 users or 2 users, I think the transition is going to come out with that kind of a facility also, which will be very nominal charge will be there, and probably you can add on to users. But typically you want to use it on your laptop, you want to use it on your mobile. Supposing you are at home, you want to use it on your mobile. In your office, you want to use it on your desktop. That is possible. So device shifting is allowed. I mean, device is not restricted. But at the end of the day, the number of users may be restricted, but that can also be, some I think the commercials can be worked out on that. Okay.
Thank you, sir. Thank you. I do have a question. Sir, may I audible?
Yeah, you are audible, sir.
Okay, sir. Actually, you have given a subscription discount today, 5,000. Is it applicable for throughout the period of subscription in next time also? That is my question.
I think transition will be
because today it will be easy for us if you allow us to at a discount of 5,000 each and every time.
I think
because as an individual IP, I am not using for office. I am as an individual IP. It will be good for us if it is a reasonable price, sir. This is my request.
Okay, I think the pre-booking price is typically applicable along with, there are 2 aspects. One is the price, and the second is extension of period. Instead of 12 months, you are getting 15 months right now. So that is
Correct, sir.
that is typically if you book it within 48 hours. For 48 hours, that you see price and that extension is possible. I'm not really sure about whether the price is applicable for future also. I think the transition probably can answer that.
No, what I'm saying, whoever is doing pre-booking, they may allow. That is the only lucrative, so that everybody should jump and do that.
Okay.
Because you are doing some giving some discount today. That is my request. At least for the IPs, not for the office purpose or the other purpose.
Your point is noted.
Individual.
Your point is noted.
Thank you. Thank you for the consideration.
Okay, I think we can hear from Mr. Hari Prasad if he wants to make some concluding remarks on how to use case laws and how to really strategize your cases. I think, sir, we can hear from you for five minutes, and then probably we can wind up after that.
After hearing all these things, I just wanted to say that it appears that it is a closed database, protected database, safe database. So whatever comes, it will come from the original judgments only. So you are safe to use it. We can call it as a safe case also. As like that open artificial intelligence, open AI, if you go, definitely it will throw some bad judgments which are bad in law, which even the advocate or the IP, if you present to the bench, you will lose your future. You will lose your credibility also. So better restricted to the safe one for safety. So it is definitely closer one. After authenticated judgments, as I said earlier, value inputs are there, protected, trusted. So better make it. I think this is the effort to empower all the IPs. It is a platform in all aspects. Like this, it is to ease you. So you can spare your efficient time in good matters. Thank you.
Great. I think we can now request Namrata ji to take it further.
Thank you so much, sir. Thank you so much, Ms. Veenu, and heartfelt thanks to Dr. Ashish Makhija, sir, and Mr. R. Hari Prasad, sir, for that insightful and engaging conversation. Yes, sir.
I have to take a call from US, so just give me some moment, right? You can continue, please.
Milk. All right. You have truly illuminated how precedents can become practice in the hands of skilled professionals. With this, to acknowledge the valuable contributions of our chat experts and moderator, may I invite Mr. Rajiv Agarwal to present virtual mementos.
On behalf of the IPNet, I extend our heartfelt gratitude to Mr. R. Hari Prasad for your invaluable contribution as a speaker. Your insights have greatly enriched today's sessions and inspired all of us. As a token of our appreciation, we are delighted to present you with a digital memento now, and we also assure you that the physical memento will be sent to your office address at the earliest. Thank you once again for your gracious presence and valuable time. Thank you, sir.
Thank you, sir.
Namrata for moderator. Hello. Yeah. On behalf of the IPNet, I extend our heartfelt gratitude to Ms. Venu Droll as a moderator for your invaluable contribution. You have performed your role wonderfully and ensured the entire session was engaging and insightful. As a token of our appreciation, we are delighted to present you with a digital memento now. We also assure you that the physical memento will be sent to your office address at the earliest. Thank you once again for your gracious presence and valuable time. Thank you.
Thank you so much.
Yeah.
Thank you so much, Rajiv sir, and thank you again to Veenu ma'am and Hari Prasad sir, and of course, Dr. Ashish Makhija sir. We are now coming to the next webinar, and we are pleased to announce that our next IP Net webinar will be held as usual on Saturdays at 4 p.m., continuing our journey of learning and leadership in insolvency practice. Stay tuned for further updates. Now, for the final vote of thanks, to formally conclude this memorable session, I now request Mr. Parag Singhal, General Secretary, IPNet, to deliver the vote of thanks.
Thanks, Namrata. Good evening, everyone. I'm delighted to extend the vote of thanks for today's webinar. Today's event has marked a new beginning in the IBC ecosystem as CaseEase has been successfully launched in the august presence of Honorable Justice Mr. S. Ravindra Bhatt. I'm confident that CaseEase will serve one-stop solution for the IP fraternity so far as ease of legal reference is concerned, and will certainly be a huge value addition for the IPs. I wish all the best to transition. First and foremost, please allow me to extend my heartfelt thanks to our Chief Guest, Honorable Justice Mr. S. Ravindra Bhatt, for sharing pearls of wisdom from his vast and distinguished career and related experience. Sir, kindly accept our gratitude for taking out time out of your busy schedule and guiding the participants and setting tone of the webinar. We look forward to many more such occasions to gain from your treasures of knowledge, wisdom, and experience. I extend our sincere thanks to Shri R. Hari Prasad for sharing with us the practical perspectives and wonderful and meaningful case studies. The deliberations made by Mr. Prasad are really enlightening and helpful in understanding the practical difficulties faced and solutions available. I would like to express my gratitude to our IPNet President, Mr. Ashish Makhija. Ashish sir's commitment and visionary leadership has made IPNet a much sought after platform of great significance for IPs pan-India. We have crossed 700 mark in our membership, which is free of cost, and it's growing every day. The insights on interpreting and applying case laws in IBC strategy is a favorite area of Ashishji, and he has always been one-stop solution and guiding light for all of us. I, on behalf of all the participants, thank you, Ashishji, from the core of my heart for your omnipresence in our endeavor as IPs. Special thanks to Rashmiji, CEO Transition, for visualizing the CaseEase and its launch. Madam, your efforts will go a long way in assisting the IPs in their professional work.
Thank you.
I also extend my thanks to Team Transition for their seamless coordination and tireless efforts behind the scene, which ensured smooth conduct of the webinar. A special note of appreciation goes to moderator of the webinar, IP Vinod Role, for successful conduct of this webinar. Madam, your valuable insights and questions that you have asked, and as well as the smooth conduct of the webinar, have greatly enhanced the effectiveness of today's discussions. Our gratitude to all the participants who joined us today. Friends, your enthusiasm, active engagement, and thought-provoking contributions have truly made this event special. I'll be failing in my duty if I don't mention the name of IP Tina Saraswat, Regional Head Central Zone IPNet, and IP Namrata Randeri, our dynamic anchor for the success of the webinar. Thanks to all once again. Thank you.
Thank you so much, sir. And thank you once again to everyone who has joined us today. We hope you leave with new insights, renewed inspiration, and excitement for what's to come. Wishing you all a wonderful evening ahead. Stay connected with IPNet and Transition. I have booked mine, ma'am, already.
Thank
you.
you.
I look forward to a lot of bookings from the people present today.
Thank you. Thank you. You are our brand ambassador.
Thank you very much.
Thank you. Thank you.